it's exceptional for a grand jury to decline to indict. Here's why. Prosecutors control the process. Let's say I have a case, I've gone in front of the grand jury, I've presented witness testimony to them. I'm a prosecutor. I don't get to testify about the facts or tell grand jurors what the facts are. I bring witnesses in front of them to explain the facts. And then I present them with an indictment. And I'm their legal advisor. I can talk with them about the elements that the prosecutors will have to establish to convict so that they can decide for themselves whether or not the evidence substantiates those elements of the charges. And then they vote. And if you're a prosecutor and you're doing your job, you understand if the grand jury has any concerns about the case. They may ask for additional witnesses. They may ask a witness to clarify some of the facts. They may suggest that they don't believe that the indictment has merit. And what you do in that setting is you offer them more evidence, or perhaps if the indictment is flawed and you haven't perceived it at this point, although you certainly should have, you might go back to your office, consult with colleagues, and even pull the indictment. There is no excuse. It's sloppiness to present these sort of facially deficient indictments, which grand jurors then say don't even meet the very low level required to get an indictment. You know, at trial, prosecutors must convict by convincing a unanimous jury of guilt beyond a reasonable doubt. A much lower standard is applied in front of the grand jury, but smart prosecutors know that that trial is coming. And so under DOJ rules, you don't go in and seek an indictment unless you believe you have sufficient evidence to obtain a conviction at trial and to sustain it on appeal. And clearly that was lacking here.